that, we have three bills on the agenda, and we're going to start with Assembly Bill 267, which revises provisions concerning the sentencing and parole of persons convicted as an adult for a crime committed when the person was less than 18 years of age. And our own Speaker Hambrick is here to present the bill. Good morning, Speaker Hambrick.
Good morning, Chairman and members of the committee. Thank you for allowing me to be here this morning. The bill deals with human lives, and the second bill you'll be hearing also. But this bill will deal with those individuals who made a mistake when they were younger and paid a price, and they're incarcerated. But we're trying to address an issue where a juvenile might have been 14 or 15 and is sentenced for an extremely long time, perhaps in some states almost life without parole. And when you're 14 or 15, we all know we make mistakes, and we're trying to correct some of that in this state. Nevada is very forward-looking on some of these bills, but we need to codify some of these issues, and I brought with me, who is sitting to my right, and you'll be hearing from him twice today, James Dolt, who is associated with the Fair Sentencing of Youth, and he will walk you through the bill, and hopefully you'll have some very difficult questions. We've got some witnesses, but we'll go forward with that. Mr. Chairman, with your permission, I'd like to introduce Mr. James Dolt, who is associated with the Fair Sentencing of Youth.
Good morning, Mr. Dolt. Go ahead.
Good morning, Mr. Chairman, and thank you so much for the opportunity to testify before your committee, and thank you to Mr. Speaker for introducing this very important piece of legislation. I'm with the Campaign for the Fair Sentencing of Youth, which is a national coalition and clearinghouse which works with formerly incarcerated youth, family members of those who are currently serving extreme sentences, as well as family members who've lost loved ones to violence, to create more appropriate and fair sentencing standards for children when they commit serious crimes. And so we're here in the state of Nevada, and I'm actually a local guy as well. I grew up in Las Vegas. I went to UNLV. I left for law school, and I ended up out in Washington, D.C., but I'm happy to be back here in my home state to testify before you all today. So thank you very much for your time. I thought that I might start just by walking everyone through the bill and then go into a little bit of explanation of why the provisions in this bill are so important, some of the history of how we got here, both as a state, and give some national overview as well. So the very first section of the bill, starting on page 2, would require judges at the time of sentencing to consider certain mitigating factors relating to age and responsibility of children regarding their culpability. And these factors are really derived from the Miller v. Alabama decision that the Supreme Court came down with in 2012 that I'll talk about a little bit later on. But essentially the broad notion is that children, they're fundamentally different from adult defendants, and there are certain mitigating factors that have to be considered, such as their age, their level of participation in the offense, whether or not an adult co-defendant was present, whether or not there's any sort of history of abuse or trauma, and what their role was in the particular offense. And so this really is aimed at creating more fair sentencing standards by having judges consider all of these factors at the time of sentencing, so that they are making sure that they are imposing a sentence that's both age appropriate and fair, considering all of the factors of youth when they commit a serious crime. Section 2 of the bill would eliminate the ability to impose a life without parole sentence. In other words, sentencing a child to die in prison. It's effectively a death sentence for children when they receive that, because they will never become eligible for parole, and that's where they will stay. And so this, again, would eliminate life without parole. It would still preserve life sentences, so I think this is a very important component to make clear, is that judges still have the ability to impose a life sentence. And so if an individual remains a danger to society, it's very possible and likely that they will continue and will remain in prison until they do die. It's just a matter of going back and saying, look, let's look at this individual after they have time to grow up and they've matured. And if the parole board feels, looking at certain factors of whether or not they have rehabilitated and have changed and are remorseful, that they are fit for a second chance, then they would have the ability to grant that. But aside from that, the sentence that would still be imposed in these cases would be a life sentence. The Section 3 here deals with the parole eligibility provisions. And so specifically, we wanted to make sure that the parole board was looking at certain factors relating to the fundamental differences between juvenile and adult defendants. And so, again, looking at the age of the prisoner at the time of the commission of the offense, the differences between both cognitive and the role of the juvenile in the offense, and how those differences compare with adult offendants, the maturity of the prisoner, the level of participation in the offense as well. And so looking at all these factors to determine whether or not an individual has been rehabilitated and should be deserving of a second chance. And this also includes, whether or not the person has engaged in any sort of rehabilitative programming, whether or not they've availed themselves of educational opportunities that have been made available to them, evidence of remorse, what they've done in their lives since they've been incarcerated to turn their lives around. And so that, in a nutshell, is the bulk of the bill. And I wanted to step back a little bit and just talk about why these provisions are so important and why we've gotten here both as a state and as a nation. Starting back in the late 1980s and early 1990s, criminologists theorized that there was a new class of super predator children that were coming of age, and they were basing this theory on juvenile crime wave that happened in the 1980s. Essentially, they projected that the juvenile crime wave was just going to continue to increase and keep going up. Of course, that didn't happen, and by the time this theory came about, the juvenile crime wave had actually begun to decline. And as a result of that, sort of the hysteria around the super predator theory notion, a lot of states began passing transfer laws that made it easier to try children in the adult system. Now, in and of itself, that's not necessarily a bad thing, but what it opened children up to was a number of different penalties that were primarily reserved for the worst of the worst adult defendants, right? So the death penalty, life without parole sentences for children, other de facto life sentences where kids were getting 100, 200-year sentences. And this really ran counter to everything as a society that we know about children, right? And so nationwide we have laws that prohibit kids from buying tobacco and alcohol, entering into contracts, getting married, serving in the military, voting. The only area that we weren't looking at these kids as being different was in the adult criminal justice system, whereas kids as young as 12, 13, 14 were eligible for these very extreme penalties. And so finally in 2005, the U.S. Supreme Court began to step in and say, we've gone too far on these extreme sentencing penalties and we need to rein it in a little bit. Justice Kennedy was the author of several of these opinions, who was a President Reagan appointee. And in the Roper v. Simmons case that came out in 2005, Justice Kennedy highlighted a couple of things when striking down the juvenile death penalty and saying that kids cannot be sentenced to death and it is a violation of the Eighth Amendment. And he first focused on, and I'll just talk about this briefly because we have some juvenile brain and behavioral development experts that will be providing some testimony on this. But the first thing he highlighted was this new emerging juvenile brain and behavioral development science that showed that fundamental parts of the brain that are responsible for emotional control, long-term planning, decision-making wasn't fully developed in juveniles, and that's the prefrontal cortex. Instead, they relied on a more primitive part of their brain, the amygdala, to actually make decisions, which made them more impetuous, which made them more prone to risk-taking behavior, which made them more susceptible to peer pressure. For anybody with a teenager, I'm certainly sure that you can relate to this. And in fact, Justice Kennedy, noted that these are things that any parent actually knows about children. But for the first time, we had the scientific evidence to show that these were in fact fundamental differences between juvenile and adult brains. The second thing that Justice Kennedy noted was the international consensus against both the death penalty and life without parole sentences for children. And he specifically cites the UN Convention on the Rights of the Child, which categorically bars life without parole and the death penalty for kids. And he also cites the fact that since 1990, there were only a handful of countries, including Saudi Arabia, Iran, Iraq, Yemen, and the United States, that had actually ever executed a youth, right? So not exactly great company to be in. And so that wasn't dispositive for the court, but it was worth noting for them that there was this sort of international consensus against this type of practice. Then the third thing that Justice Kennedy noted in the Roper decision, and the reason I'm going through all of these is that these are recurring themes in all of the trilogy of cases that came down by the court, and they inform the later decisions. But the third thing that Justice Kennedy noted is that there's a great difficulty distinguishing between a juvenile offender who might be irretrievably depraved and is beyond rehabilitation, and those who are, and the vast majority of them are. And he highlights this great difficulty that the psychological community has in distinguishing between the two, because their brains are not fully developed, and that they have, and because of that, they have this heightened capacity to grow and change and become rehabilitated. So based on all of those reasonings, the court strikes down the death penalty for kids in Roper v. Simmons. And 5 years later, in a case called Granby, Florida, the court comes back, and here they're examining life without parole sentences for non-homicide offenses. And again, relying on everything that the court said in Roper, the court, again in an opinion written by Justice Kennedy, highlights the fact that life without parole sentences are akin to the death penalty because, in fact, the child will never leave prison alive. They'll leave prison in a box. And so it is, in fact, a death in prison sentence when we impose these types of sentences on children. And then he goes on to talk about the fact that most kids, when we're looking at them, there is this great potential for rehabilitation. There's a 50% decline in criminal behavior by the time juvenile delinquents or kids that engage in criminal behavior reach the age of 22. By the time they reach the age of 28, there's a decline of 85%, right? So there's no more recidivism for the vast majority of kids who engage in these types of serious crimes. And so that was very informative for the court, and they again struck down life without parole sentences for non-homicide offenses and held that states must provide individuals convicted of non-homicide offenses with a meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. And then 2 years later, in a case called Miller v. Alabama, the court took up the issue of life without parole sentences for homicide offenses. And here the court ends up invalidating 28 sentencing schemes across the country and requires that sentencing judges consider the mitigating factors of youth anytime that a kid faces a potential life sentence. And so these provisions actually apply to states that had both mandatory life without parole sentences as well as discretionary life without parole sentences. And again, the Miller court, going back to everything that it had said in Roper and Graham, comes up with this opinion and strikes down these sentencing schemes based on the Eighth Amendment. Since that time, several state Supreme Courts have ruled on the issue of retroactivity of the Miller decision and whether or not the individuals who received life without parole sentences should in fact be resentenced under the Miller decision. State Supreme Courts in Texas, Mississippi, South Carolina, Florida, New Hampshire, New England, Wyoming, and Massachusetts have all ruled that this decision should be applied retroactively and that the individuals who were previously sentenced to life without parole should get new resentencing hearings, and the mitigating factors of youth that were articulated in the Miller decision should be considered at that time and what sort of progress the individual has made since their incarceration. And this is also, and part of these decisions, I think, also highlight, what we know about a lot of these juvenile lifers as well. Nationwide, there's about 2,500 individuals, 16 here in the state of Nevada, that are serving life without parole sentences. 80% of them witness violence in their homes and neighborhoods on a regular basis. 50% were physically abused. 20% were sexually abused. 80% of the girls who are serving life without parole sentences were sexually abused. Over a third were homeless at the time that they committed their offense. 25% of them were actually serving these sentences for felony murder, so they may have not even been the individual that committed the homicide offense. And then 60% of them committed the offense with an adult co-defendant. So given everything that we know about the juvenile brain and behavioral development science and how kids are susceptible to peer pressure and adult influence in particular, these characteristics, I think, helped inform the court as well that, these kids are fundamentally different. And now that doesn't excuse the behavior, right? So we're still talking about very serious offenses that kids need to be punished for. But it does help us to understand how kids could end up in these situations and sort of why they might be more deserving of mercy than other individuals who are adults who commit similar offenses. So in response to these U.S. Supreme Court cases and the emerging juvenile brain and behavioral development science, several states across the country have begun to eliminate life without parole sentences wholesale for kids and create more age-appropriate and fair sentencing standards that are in line with AB 267 here. Let me just highlight a couple of those states. In 2013, state of Texas, in a special session called by Governor Rick Perry, eliminated life without parole sentences for children. They are actually one of the first states to begin paving the way for this in the wake of the Miller v. Alabama decision. Wyoming, Montana, Kansas, Kentucky, West Virginia, Massachusetts, Hawaii, Alaska, and Delaware all have all enacted legislation to eliminate life without parole sentences for juveniles. The reason I highlight those states is because there's a broad geographic and political diversity amongst them, and so this is very much a bipartisan issue that we've seen really across the country. I'd also highlight that a couple months ago, last month, the American Bar Association, in Resolution 107C, called on all states and the federal government to eliminate life without parole sentences, both prospectively and retroactively as well. And we have several folks that have also been supportive of these types of measures. And so before I close, I do just want to highlight one thing that I forgot to mention. We have been working with the DA's Association on a couple of amendments. And so one of the things that one of the amendments that we've talked about in the bill is to actually make sure that we distinguish out between the homicides and the non-homicides, and actually increase the term of years that would be required as a mandatory minimum to serve for homicide offenses before the individual would become eligible for parole, and that it would only apply to a single homicide offense. And so that's one of the amendments that we've been working with and have talked with the DAs about. And I think they're going to come up and tell you how they feel about those amendments. But that's one of the things that I forgot to mention. And I'll be happy to answer any questions about that. And as I close here, I think there are a couple of different ways to look at this issue. There's the one through the legal lens of everything that I've highlighted from the Supreme Court cases, the emerging juvenile brain and behavioral development science, and also the moral aspect of this. And former Speaker of the House, Newt Gingrich, in an op-ed in one of the bills that we worked on in another state, wrote that Jesus calls on us to do unto others as we would have done unto ourselves. And we should think about that if these were our children, how would we want them treated if they ended up in these unfortunate circumstances? And we'd want them to have second chances. And with that, he called on Governor Brown actually to pass similar legislation in California. And I'm happen to be Catholic, and I'm a man of faith. And one of the reasons I'm doing this and this kind of work is because of my faith. And one of the things that I'm reminded of is Jesus on the cross when I think about this. And Jesus, when he was being executed by the Romans, he calls out in one of his last moments, forgive them, Father, they know not what they do. And because of that act of mercy, we as sinners were all saved. And for me, looking at this issue, if our children aren't deserving of our mercy, who amongst us really is? And so part of this is about faith. Part of it is about finding the moral center of the state of Nevada, the moral center of the United States. And with everything we know from a scientific standpoint, this really is great policy that has been enacted around the country. And with that, I'll go ahead and close and be happy to answer any questions.
Thank you, Mr. Dole. Do we have any questions for Mr. Dole at this time? Mr. Nelson.
Thank you, Mr. Chairman, and thank you, Speaker Hambrick, for bringing this bill. I just have one clarification I want to make for the record. As I read Section 3, Sub 1, and then also the very last sentence of the bill, it appears that this will apply retroactively so that anyone who has already been sentenced to life without the possibility of parole will now be eligible for parole. Is that correct?
And the current iteration of the bill, yes, sir, that is correct.
Okay. And that's in line with the other cases you mentioned that were construing Miller v. Alabama?
The state Supreme Courts that have weighed in on the issue, yes. Texas, South Carolina, Mississippi. Of the bulk, there's been 14 state Supreme Courts that have taken the issue up. 10 of them have ruled in favor of retroactivity of the Miller decision. The Supreme Court of the United States just granted cert in a case called Montgomery v. Louisiana, and so they're going to be deciding the issue nationwide probably within the next term.
And did Miller v. Alabama say anything about retroactivity?
So the reason I think the bulk of the state Supreme Courts have ruled for retroactivity is because there was a companion case with the Miller decision called Contrell Jackson v. Hobbs. Jackson v. Hobbs was on collateral review, so he had exhausted all of his direct appellate reviews. And so a lot of the state Supreme Courts, when they were looking at this issue, said, look, why would the Supreme Court have, taken up Jackson's case unless they meant for it to also apply retroactively? Because Mr. Jackson had been convicted in the, I believe it was like 1980s. And so for them, that was enough evidence to sit there and say, and plus with looking at the issue of the Teague analysis and whether or not it was a rule that was meant to be applied retroactively. From their perspective, it was a substantive rule because it removed a particular type of penalty from a particular class of offenders, and that was mandatory life without parole from juvenile offenders. And so that, for those state Supreme Courts, was the underlying rationale for why they ruled for retroactivity.
Okay, thank you.
You're welcome.
Okay, for the purpose of the hearing, I need to let everybody know we're going to end this portion at about 9 o'clock. I've got probably, it looks like almost 30 people signed up who would like to speak. So we're going to have to compress some of that, trying to be fair to everybody. I have nobody signed up in opposition to this bill. So between now and 9 o'clock, we'll hear from all the proponents of it. I have 2 people that are signed up in neutral, but they've not signed up to speak. So just want to let everybody know that in advance here as we go forward with the hearing. Ms. Diaz, you had a question? Mr. Araujo, pardon me.
Thank you, Mr. Chair. A quick question. Out of the folks that are the young children currently serving life without the opportunity of parole here in Nevada, who's the youngest and how old is that person?
Oh, gosh. Their current age, I might not be able to answer that. We have attorneys here who have represented some of these folks who might be better suited to answer that. But in terms of their age at the time of the commission of the offense, I think the youngest was 14.
Appreciate it. I just think it paints a clearer picture as to who exactly we're talking about and who would have that opportunity for redemption.
Absolutely. An eighth grader, essentially. Yeah.
Thank you.
Mr. Jones?
Thank you, Mr. Chair, and a presentation was well done. Obviously, you know this inside and out, so congratulations on that. But now I'm going to bring you just to our state, not the federal. Do you have any idea or statistics on how many people would be eligible for this bill in the state of Nevada? Are we talking 50, 100, 10?
So 16 that we're
16?
aware of yet. Yes, sir.
Okay. Yeah. Thank you.
All right, any further questions? I have some. Oh, Mr. Thompson, go ahead.
Thank you, Mr. Chair. Just some clarification. I'm following up on Assemblyman's question about the retroactive, but that's only if they've served for 15 years, right?
Right.
That's what it's saying on here. So
That
I
in
just
the
want to
bill, yeah,
clarify
they
that.
still have the life sentence, and then they would be eligible for parole after 15 years. We've been talking with some of the amends with the DA's Association, so I think there's going to be some changes there. But yeah, right now under the current iteration,
To make it less years?
make it
served?
more years, so it'd be 20 years for the homicide offenses.
Okay.
Yep.
All right. Thank you.
All right, Mr. Dole, since there's nobody to testify in opposition, I want to play devil's advocate a little bit with you for a minute. Now, all of these cases that you listed in Section 1, all of these things that, the development and whether or not the child was abused and so forth, don't public defenders and judges and juries and everything right now, these are serious capital offense cases. Aren't those things already being discussed prior to sentencing people in Nevada?
So not all of the factors that were articulated by the Miller Court are necessarily considered at the time of sentencing. I think at the time of transfer hearings, a lot of those provisions are, but at the time of sentencing, not necessarily. So
During the trial, aren't those things brought out?
So when they're sometimes by the defense attorneys, they certainly could have been brought up, but they weren't mandated to be brought up as the Supreme Court required in Miller v. Alabama. And that's why when we look at, for instance, the South Carolina Supreme Court, there, much like Nevada, it was a discretionary life without parole state, and the Supreme Court in that state actually ruled that Miller was applicable to South Carolina because these mitigating factors weren't specifically on the record and weren't considered at the time of sentencing.
Okay, and then your comments of the development of the brain, isn't it also true that in many adults, especially that are convicted of violent crimes, that there's a pretty consistent pattern of showing them to have, with IQ testing and all that, substantially below average IQs, even though they're adults?
I can't necessarily talk about the adult specifics, but in terms of the child brain development science, what we know is that, and I think this is also relative in some of my comments that I mentioned before about the line that we've drawn regarding what type of activities that we allow children to engage in. So I think there's been a general recognition from the psychological community and also society more broadly that children don't have the ability to make as well-informed decisions. And certainly as neurological development continues to happen and the brain continues to mature, children become more able to make those decisions, right? But as a general matter, that doesn't happen until right around 18, 19, 20 years of age. And that's why the Supreme Court also drew that line there in the Roper decision, in the Graham decision, is because that's what we know from the juvenile brain behavioral development science, that the overwhelming majority of these kids, that's when their brains are still developing, still maturing.
And one last question for you, and that would be, the concept is, you can't have a life sentence without parole, but obviously the sentencing of juveniles has been going on a long time, and in many cases they have an opportunity for parole. What is the recidivism rate traditionally for people in that, say, 14 to 17-year window who committed a very violent crime, was sentenced with the possibility of parole, who then repeated a violent offense after they'd been released? Do you have any idea?
I'm sorry, I don't have those statistics. I have the broader national statistics that I cited earlier, which is that generally as individuals, they call it aging out of criminal behavior. By the time they reach 22 years of age, over 50% no longer recidivate, and then when they're 28 years of age, it's 85% no longer recidivate. And so that's the general national statistics that we know of, but we haven't specifically tracked the population, and no studies have been done specifically about those types of instances that you just mentioned.
Because obviously my concern going forward with this is, okay, so we recognize that the psychology that was developed in the 80s because of a crime wave may in fact be in error. But on the other hand, we're now dealing with a new kind of psychological way of looking at this. Are we going to release people out there that may in fact end up being violent again and murder somebody else? And, you know, my job, frankly, is to protect the interests of the public. That's my number one concern in these things. So I want to make sure that when we go and possibly do a change like this, that down the road they're not going to come back and say, gee, Hanson, when you were chairman of the Judiciary Committee and you started letting you made it mandatory that these kids were getting out, now we've had this repeat offender problem where these kids, when they were 14, committed a crime, and then they got out at 30, and then at 35 they murdered somebody else. You know, that's a very legitimate concern, because recidivism, as you know, has been a consistent concern in the criminal justice system for a long time.
Absolutely, and there's no one more. You know, before I did this work, I worked on anti-human trafficking legislation, and so and I helped draft AB 267, and it was all about making sure that there were tough penalties in place, and nobody wants anybody who's violent on the streets, and nobody wants anybody to be hurt or injured. And so it's very important that, you know, if these individuals remain a danger to society, that they don't get out of prison, and that's why there's still the mandated life sentence, right? So they would still get the life sentence. It's just the parole board would have the opportunity to go back and take a look at them, right? So if they haven't changed, if they remain a danger to society, you're absolutely right, Mr. Chairman. Nobody should be getting out. They should spend the rest of their lives in prison. This is just about saying, hey, what we know about kids is the vast majority of them change. Let the parole board take a look at them, determine whether or not they have changed and been rehabilitated, whether or not they are a danger to society, and let them make that determination. And if somebody is a danger, keep them in prison forever.
Very good. Well said, Mr. Dold. Well, at this time, seeing no more questions, thank you very much. Speaker Hambrick, is there anybody else that you'd like to have present at this time before I just open it up to the audience as a whole?
Not at this bill, Mr. Chairman. The second one coming up, most likely. Thank you, and thank you, committee, for your set.
Actually, I do have a list, so I will start calling them up. Is that how?
If I may, we have two formerly incarcerated youth that would like to come forward.
Very good. I think
Five of them?
5 of them. Oh my goodness.
Okay.
Well, here's what we're going to do. I got 3 seats up there. I'd like to have all 3 seats occupied, and then after all 3 give you testimony, if there are any questions, we'll ask at that point. So, come on up. Who would like to start? Mr. McElrath Bay, we met yesterday. Nice to see you again. Go ahead and hit the microphone button, state your name for the record, and tell us the story.
Yes, thank you, Chairman. I'm very happy to be here. For me, whenever I come to these committee hearings, it's a very emotional experience for me because I reflect upon my own personal experience. Today, I am a youth justice advocate with the Campaign for the Fair Sentencing of Youth.
Be sure and state your name.
Xavier McElrath Bay.
Very good, thank you.
And I'm a youth justice advocate with the campaign, and a part of my role is not only to go out and advocate on behalf of youth, but also to coordinate a national network of formerly incarcerated individuals. That national network is called ICANN. ICANN is the Incarcerated Children's Advocacy Network, and currently we have 25 members. You're looking at 4 of us here. Well, you'll soon meet Tracy also. One thing that's reflective in our lives is that we were once deemed as worst of the worst. We were once deemed as kids that would never change. We were given some very extreme consequences for some very serious offenses. When I was 13 years old, I was arrested, charged, and I was later convicted to serve a 25-year sentence in prison for my involvement in a gang-related first-degree murder. At the age of 13, I was still in 7th grade. I probably weighed about 112 pounds. I remember that because of the school that I was in. When I was wrestling, I was 112, and I don't imagine I had gained much from that point. I was probably 5'3", 5'4". At that time, what was for the most part unspoken during my sentencing was the fact that I came from a very adverse childhood. Very early on, I was placed in foster care because of allegations of abuse, or actual actions of abuse from my stepfather. After 2.5 years of being in foster care, returned home, and yet and still, there was still very much the dominant theme of abuse and neglect. I also had a family that contended with psychiatric problems. My mother was schizophrenic. My brother, who was older than me, was also schizophrenic. I had a very abusive and an alcoholic stepfather who hesitated at nothing at hitting us and kicking our dog. This was something that we experienced very early on, something that as children we could not escape. Unfortunately, a lot of that trauma, I think, manifested itself in some very devastating ways. And I think for the most part, it's because I was driven for the most basic and fundamental human needs, and those needs were for love and acceptance, a sense of safety. And I think, unfortunately, at that age, I saw it in the streets. And when I thought that I found it, I made some very horrible decisions. And most importantly, I ended up making a very tragic mistake. I was responsible for the loss of another life. I played a role in what was the unfortunate demise of another youth, and not only that, but also a community and a family that to this very day suffers. But I sit here to tell you that I live my life as an eternal apology to him and his loved ones. I live my life as a reflection, as a capacity that every child possesses to change. When I was in prison, I eventually matured, I grew, and I came to discover who I really was inside. I came to realize that I really wasn't that little gangbanging punk, that in reality I had hopes, that I wanted to be able to live a normal life someday. And it made it sound funny. I used to watch a program called Saved by the Bell. I'm not sure if you've ever seen that. But that show to me, when I used to watch it, made me imagine, like, wow, what if my life was like that? You know, what if there was no gangs and no drugs? And what if there was, my biggest concern was whether or not I was going to win that dance competition after school? Like, these are things that I fantasized about. But I also thought to myself, but you know what, Xavier, it's not too late. You could do something with your life. You can get out and you can become somebody. And so I got into school. I ended up getting 2 associate degrees, Associate of Arts and Associates in General Education. Along with that, I decided to get a bachelor's. I got a bachelor's in social science with a 4.0 GPA. Never got an A a day in my life. And I was actually getting A's while I was incarcerated. And I was inducted into the Franklin Honor Society for Outstanding Scholarship. Soon after, I was certified in computer technology. Had never even been on the internet, but I had a dream. And I believed in it. And coming out, I was able to allow my life to be a reflection of that eternal apology. And I've been working for the past 12 years in positions that were designed to keep children out of the criminal justice system and out of the grave. I've done quite a bit in terms of gang intervention, bias prevention. I was a ceasefire outreach worker. I was a juvenile justice diversion program coordinator with Alternatives. I also went on to work with Catholic Charities, a street intervention specialist. And most recently, before this position with the campaign, I did 5.5 years of research with Northwestern University as part of the Northwestern Juvenile Project, in which I had interviewed and assessed the mental health needs and outcomes of over 800 formerly incarcerated youth, much like us. But I came to realize that in all reality, we do have the capacity, that I was not the exception to the rule. And I became to become more and more inspired by the individuals I had met, and I realized that something had to be done. That we had to do something in regards to amplifying these stories and to sharing these, very inspirational but yet not uncommon stories that kids can change. And I really hope that you give these individuals here in Nevada the same opportunity that I had. Thank you.
Thank you, Ms. McElrath-Bay. Sir, go ahead and state your name for the record and go ahead.
Thank you, Mr. Chairman. My name is Mario Taylor. I was 15 years old when I was arrested for first-degree murder with the use of a deadly weapon, and I pled to a second-degree murder, which ended up giving me 2 10 to 45-year sentences. And at the time, it was 1996. I was in the 9th grade. And just imagine a kid being told in months that you have 90 years. So I'm sitting there in front of the judge, and she said it in months. So I'm trying to figure out, well, how many months, how many years is 90 years? Because it was a large number. And I was like, huh? So I just sat back and she said, well, it's 90 years. And I was like, 90 years? And then she asked me, she said, well, I can't dumb down this crime. She said, true enough, you were a good kid who made a bad decision. She said, so I'm going to punish you for that. And I said, okay, well, she asked me, well, and Nancy Becker was my residing judge who was a Supreme Court justice after. Now, and she said, well, what are you going to do now? I said, well, I'm going to just try to do the best that I can with what I have. considering the circumstances, and I just explained to her that, well, just imagine I was the same height as him. I was maybe 120 in the 9th grade. Now I'm around a bunch of adults, and I'm literally like in a cell with a grown man. So every day I would wake up in a cell with a grown man, not knowing what would occur. Like, if anything would occur, and now I have to put this machismo, even though I was in a gang, and I felt like I was really tough, and I really realized that I'm not as tough as I really thought I was, because here I am, faced with all this adversity. Well, what do I do? So the only thing that I could honestly do, I felt kind of hopeless, but I also took full responsibility for my actions in the crime. I explained to everyone. I returned myself in. I considered myself at 15 doing the right thing for that, in hopes that I could give the family some type of justice, knowing that what I did was absolutely wrong. His name was Christopher Beaver. I walk with him every day. His mother actually forgave me, and I'm like truly, truly grateful for that. And I don't know where I would be right now without her and her family, and just the fact that she actually said that, well, I forgive you for taking my son's life, and I hope that you do the right thing. And she gave me the opportunity to do the right thing. And it was because I actually had a chance to sit down and reflect on my own life and reflect on my own actions. And I realized that 5 years, it was clearly not enough. 10 years probably was clearly not enough for me to actually be broken and to realize that I needed to change my life, because while incarcerated, I got my associates as well in general studies. I graduated with 3.8 GPA. I immersed myself in every self-help opportunity. I pretty much mentored the youth while I was there. I was pretty much like the ideal inmate while I was incarcerated. And I realized that, well, if I can do that here, well, why can't I take that same thing? And if I get this opportunity to go home, well, I have the chance to actually do this. So upon being released, I found myself in this predicament. I said, okay, well, I have the opportunity now. Here it is. There's an organization called Hope for Prisoners who are actually helping people, and I immersed myself with them. And now that I'm involved with them, I help so many individuals who are coming home and who need jobs and who need help and who need guidance. And it's because that I had the opportunity to come home, and that someone actually believed in me and gave me that hope in myself, that I found the hope in myself. And I actually found that I am worth something, and that I'm not someone who just takes from the community. I can actually be an attribute, and I can actually give back. So I've done that, and I'm continuing to do that, and I will continue to do that every single day. And every day I walk with that on my mind, with that at the forefront. And every day I wake up, and as I sleep at night, I know that these are the things that have to be done. And there's no way, there's no day off. There's no moment where you can just say, well, I'm not going to help. No, I help every single day in one way or another. And without these people, without this help, there is no redemption for us. I was someone who was considered helpless. I was someone who said, well, let's just lock away the key, even though I grew up in a family with both my parents were on drugs, mother and father. So I really had no direction. I was living with my grandmother for a while, and that was the only hope I really had. And then beyond that, once I moved back to Las Vegas, it was just all downhill from there. So knowing that, and then to come into adversity, and then to commit a crime, and then to go to prison, and then get out of prison, and then be given a second chance, was all the more reason that I needed to actually do the right thing. So I'm just grateful for the opportunity, and I know that if you give these other children a chance, and I know a lot of these incarcerated youths that are in the state of Nevada today, and I actually walk with them and talk with them, and I know that they actually deserve a chance. And if you give them a chance, I'm pretty sure that they'll be successful, like we all have been. Thank you.
Thank you, Mr. Taylor. Ma'am, go ahead.
Thank you. My name is Sarah Cruzon. I'm from California. I was given a life without the possibility of parole sentence plus 4 years in 1994. I was convicted of first-degree murder. It's an honor to be able to be here, to be able to talk to you guys, and to let you know a little bit about my story, and also possibly put a human face to these young children that are sentenced as adults. I was sentenced at the age of 16. Prior to that, I had goals. I had a 4.0 GPA. I wrote a book about drugs and its effects. I had aspirations to be a pediatric surgeon. Even though I was raised in a impoverished neighborhood with a single-parent mother who was addicted to drugs, the abuse that I endured didn't really take effect until I was a little bit older. But for a 9-year-old child who has to endure the abuse from a mother, they're not able to comprehend what's happening to them, let alone be able to express the issues. So from 9, 10, 11, 12, 13, 14, 15, 16, the traumas that I experienced were some that I can't even talk about some of them. I'm not saying that justifies by any means my crime. I live every day with the remorse and the grief for taking someone's life, regardless of the circumstances. However, I do understand that as children, we are faced with a lot of challenging situations, and those who come from more of a challenging background with the lack of parents and the lack of guidance and the lack of understanding between morals and principles and integrity, the decisions that I myself made were based more so on a belief I needed to survive or to stop the abuse that was happening to me. While I was incarcerated, I met many young people who also had the same experience as myself. Some of them were not able to handle the pressures of prison. Chowchilla is one of the largest women's facilities in the world, where I'm housed with 7 other adult women. So being there as a child, going in, weighing 118 pounds, and having to share a very small space with grown women was a trauma within itself. The lack of resources that are made unavailable for those who are tried as an adult is also an obstacle for young people, because at that age, at 15, 16, we don't understand the legal jargon. Anyway, I just want to say that I do believe that there are those who are incarcerated that, if given an opportunity to come before a board and to show who they are worthy of a second chance. Thank you.
Thank you, Ms. Cruzan. We are going to go down south now. We have a couple people there that would like to testify. Switch the camera a little bit so I can see. There we go. One person. Sir, go ahead and state your name for the record and proceed.
Good morning, sir. My name is Marcus Dixon. At the age of 14 years old, I was locked up and charged for first-degree murder with the use of a deadly weapon. That was in 1998. In the end of 1999, close to 2000, I was found guilty of first-degree murder with the use of a deadly weapon and sentenced to 40 years to life. The 2 years that I was in the Clark County Detention Center, I never seen my mom. She never played a major role in my life, even before being incarcerated. My lawyer was Christina. She became more like a parent to me, and throughout the process of me going to prison, when I was immediately introduced into prison, there was a program called the Youthful Offenders Program. I went to the Youthful Offenders Program. Now, I have remote asthma, and remote asthma means it only flares up during the winter months. So I was in the Youthful Offenders Program, and we had TP, which is like PT, physical training. And I would do everything in my power to stay fit during the physical training. And I remember that the person who was running the program, his last name was Carlisle. He said he wished every kid could be like me, that always had drive. It was a lot of times in my life when I was in prison. So let me go back to when I was 14. When I was 14 years old, I was offered 10 years to 25 years for my crime. But being that I was 14 years old, I really didn't understand yesterday. I really didn't understand the day before. So 10 years was like the rest of my life. And me looking back on juveniles that's 14 years old that get charged, 13 years old that get charged as an adult for a first-degree murder charge or any charge that could certify them as an adult, I honestly don't believe in my heart that they have the right or that they have the knowledge to make a decision as far as accepting a deal to go to prison, because I didn't understand 10 years. Now, after me not understanding 10 years and then I was sentenced to 40 years to life, the only thing I wanted to do was go home. I never really had the concept or the understanding of the crime that I did commit. So I just wanted to go home. When I was 18 years old, I really started to get an understanding of the crime that I committed. I wrote Daryl Crittenden's family. His grandmother forgave me of the crime, which helped out a lot because it was something that was always on me. And when it helped, when she forgave me for the crime, I decided before she even forgave me, I decided to live my life the way I could, however I could live my life to let him live through me, being that I took his life. So I did everything I possibly could. I went to school. I got my education. I went to college. I did every program that was in prison. Every program. I stayed away from gangs. I stayed away from drugs. I stayed away from mainly most of the other inmates unless they were being positive. It was a lot of people in the youthful offenders program, one being Angel Diaz that was around me the entire time. And our birthdays is close to each other, so we studied philosophy. We went to college. We did everything, and we always communicated with one another because he was 16 or 15 years old when he got arrested, and he was also sentenced to life. So throughout the process of prison, me and him was always around each other. Then it was another guy that I met named Christopher Williams and Juan Castillo. They were sentenced to life without the possibility of parole. And the only desire that we've all ever had was to be better people and one day have a chance to be back in society. I've been out of prison for 2 months. I got a job, a house, and a car. I just opened my first bank account. I graduated to Hope for Prisoners. And the only thing I want to continue to do is move forward in life. I've been speaking to youth since I've been out of prison and trying to get inside to juvenile justice centers down here in Las Vegas to talk to the juveniles. And I've talked to a lot of people, and they told me the only reason I can't get into the juveniles is because of my background, but they believe that I have a great story and I can help kids. So I've spoken to a couple kids that's been out here, like friends of mine before I got incarcerated. They had children, and one of her son is getting in trouble, so I've spoken to him. And she told me since I've spoken to him, he asked me, why can't his dad be like me? And his dad never been to prison. So she's like, I can't tell you, but this kid, I want to be a part of his life because I don't want him to go down the same path I went to. He's 13 years old. Now he's starting to do better in school as far as bringing his grades up. My nephew is about to be 18 years old. He told me the only reason he stayed out of trouble is because he always listened to me as far as me giving him advice the entire time I was in prison. He told me I'm more like his dad than his own dad, and his dad been in his life the entire time. He told me he looked up to me. So I explained to him, today me and him can grow up together. When I was 14, what I should have been doing at the age of 18 years old, I have to do today at 31 years old, which I have no problem with. I'm happy about it. I'm extremely thankful that I can do everything I possibly can because I'm free, I got life, and I can help people the way that I wish I could have been helped. And I believe in my heart that every kid still has the chance and opportunity to learn. And if I can help them, I'm willing to do whatever I can. Because, like, I talked to some people that were in prison, and they asked me, how is it being free? So my response was, I don't believe I should have ever left the free will in the first place. But it's still that I believe everyone deserves a chance. Now, I was 14 years old. I didn't understand anything, honestly, until I was like 18. I started really coming into understanding what was going on in life and what meant something. So still today, I'm 31 years old. I did 17 years in prison, and I was fortunate to have that life, 40 years to life, reduced to 15 years to life. And I'm here. I'm doing everything I possibly can, and I will continue to do everything I possibly can. I'm thankful for this chance, for this opportunity, because another thing I'm thankful for is the justice system, because I did learn. I even seen my district attorney who had me found guilty when I was at trial, and thanked him because I felt the need that I should have been punished for the crime that I committed, but I don't believe that I should have spent 40 years in prison. I would have been 54 years old, from 14 years old to 54 years old, and I'm thankful that I had the chance, opportunity to start my life today.
Thank you very much, Mr. Dixon. We'll come back up north again. Who would like to testify at this time? Go ahead, ma'am.
Hi, my name is Tracy Rutherford. I was charged with first-degree murder when I was 16 years old. The victim is my stepbrother. Unfortunately, I had the unique opportunity at that point to be a part of the grieving process of my family and being the victimizer. I was not the one who committed the murder. I had an adult co-defendant who committed the murder, and I was scared to death and kept my mouth shut, and they charged me with the crime as well. I won't take much of your time. I want to highlight a couple points. In 15 years I did in prison, I went to school, got my high school diploma, got my GED, got a college degree, started programs, went through intense and extensive mental health programs to try to figure out what behavior led me there, fix those problems, and become a better person. I'm not a criminal. I was charged with a crime, but I'm not a criminal. I am now a taxpayer, a voter, a military wife. I am a mother of a beautiful 8-month-old. I pay my taxes every year. I am a wonderful, productive citizen of this society. And I was given the opportunity to learn from my mistakes. As a youth, teenagers make dumb decisions. I learned from my mistakes, just as I have spoken to probably 10 other juveniles who I was incarcerated with. We would sit outside and talk about the changes that we've made, what we wish that we were doing, the opportunities that we wished we had but made the mistake. I learned my lesson after about 7 years. It took me about 7 years of bumping my head against a brick wall, sometimes literally, to figure out changes that I needed to make and to move forward and to stop being a little kid who made little kid decisions. I'm now a mentor also for juveniles. I try to contribute as much as I can to my community. I now live in Seattle, Washington. I did my time here in Nevada. My family is all very supportive of me. My stepbrother is the victim of my case. My stepmother and I are still very close. She's still married to my father, and we have a very close and personal relationship. She understands that I made a mistake as a kid, and I made kid decisions. She's the most amazing woman I can think of. I live every day of my life knowing that I need to make her, my family, and especially my stepbrother, the victim of my case, proud, so that he does not die only in vain. Kids change. 15 years after 15 years, just a review is not saying you're going to get out of prison. It's an opportunity for review and for modification. It's an opportunity to see if these children have grown. And that's what's important, is to see if we're not just throwing away taxpayers' money and locking kids away forever and ruining life after life after life, because it has a ripple effect. It affects the families of the people who are in prison. It affects the victims' families. Most of the time, there's opportunity. There is growth. There is a time, and after 15 years or 20 years, it's just a review to see if it needs to be changed. And I think that you guys would be very pleasantly surprised at how many youth do change, that they did make juvenile decisions. Thank you very much for your time.
Thank you, Mrs. Rutherford. Go ahead, ma'am.
Good morning. My name is Bridget Walsh. I'm a developmental scientist. I am recently a tenured professor, and I spend all the hours of my day studying child development. And one thing I want to underscore is the robust finding that the prefrontal cortex, responsible for thinking, planning, and higher order thinking, isn't fully developed until the age of 25. Before that time, the limbic system is overactive. We expect young children to have unbalanced brains. We expect them to make emotionally driven decisions and not demonstrate dialectical thought, considering a synthesis, an antithesis, a thesis, an antithesis, and a synthesis, which is characteristic of adult thinking. Before this time, adolescence is a time of heightened risk-taking due to the unbalanced limbic system and the undeveloped prefrontal cortex. There has been some research conducted by Dante Cicchetti that looks at children who have been maltreated, sexual abuse, physical abuse, emotional abuse, whatever maltreatment might be. And for them, the limbic system might always be out of whack, the amygdala, the hippocampus, and the hypothalamus. But because the brain has a degree of plasticity, there's a degree of hope combined with realism that individuals can change in adulthood.
Thank you very much. I'm sorry. Go ahead.
Thank you, Mr. Chairman, Vice Chair, and members of the Judiciary Committee. My name is Christina Wildeveld, and I'm here as a representative of the Nevada Association of Criminal Justice and as a private criminal defense attorney who has spent the majority of my 20-year career working towards numerous reforms this body has passed, and indeed this very bill you're considering today. I'm grateful for Chairman Hambrick for introducing this bill. I began my career 20 years ago as a law clerk in family court, working with abuse and neglect cases and juvenile delinquency cases. I quickly came to understand the special challenges and impact of the juveniles in their lives in our community. I saw firsthand the absence of any real good chance these children who are in the system faced. The majority of the kids who are basically condemned to die in our prisons are there for no other reason than their age at the time they committed their crime. The history that I had working with the courts has shaped my career. It has given me the necessary context to understand the need for reforms and the passion to fight for them. In 1997, I was hired by now Supreme Court Justice Michael Cherry in the newly opened Office of the Special Public Defender, doing only first-degree murder cases. Because of my passion for helping children, I was assigned the younger children in the office who were facing murder charges and death penalty charges. At the time, the death penalty was still allowed as a punishment for juveniles. I would meet with these kids, barely older than my oldest daughter now, and even though most were guilty on some level of the offense charged, their understanding of the process, of the system, of their own future and consequences could only be described as innocent and naive. Sometimes they came to me cocky for sure, a product of street life that started too soon. Others would just cry uncontrollably. Some almost immediately displayed the emotional instability of the abused children they were. But one thing they all had in common, and that sticks with me today, wasn't a calculated how can we beat the charges or even the outright denials of the crimes they committed, but a simple, understandable question from a child in a bad place. Can I now just go home? Please just let me go home. My job then, as it is now, in each case became less and less about providing evidence as to their guilt or innocence, but rather more about attempting to mitigate the inevitable mandatory sentences they were about to face under the laws as they were written, with both the prosecutor and the court to present them in the context of their lives instead of the few worst seconds they all soon after regretted. Murder with use of a deadly weapon at the time and still in place for most was 40 years to life. So those kids who are now incarcerated didn't have any other option. There was no transfer hearing. There was no mitigation ability to present mitigating evidence. Their sentences were 40 years to life, life without the possibility of parole, and for some, the death penalty. A lot of them who are facing life without the possibility of parole were threatened with the death penalty when they first came to court and pled to life without the possibility of parole. They had no other choice. And that's true whether they were the principal actor who took a life or just a conspirator or an aider or abettor. Under the laws in the state of Nevada, when a juvenile is charged with murder, no matter what their age, they are automatically charged in adult court. They do not go before a juvenile court for a transfer hearing. Murder Murder is automatic and non-appealable. Even if they are children of addicts, victims of great abuse, the charging document alone magically turns a 12-year-old into a 19-year-old adult. They are treated as adults when they are clearly not adults. They're 7th and 8th grade and 9th graders. They're kids. The legislation you have before you today is the last reform necessary to ensure that we never forget that even certified children are different from adults. They are more impetuous, their problem-solving and comprehension skills have not yet fully developed. They are easily misled or confused in stressful situations. Yet as an attorney working with these kids, often within hours after their lives are changed forever, they still don't comprehend or understand. While it may be instinctive on some level to view the world in terms of doing the crime and doing the time, passing this bill does not forgive these kids' crimes, but acknowledges what science says we cannot ignore. They still live with their crimes forever. I know a lot of these kids. I know their vulnerabilities, their openness to rehabilitation, their deep remorse. They want to be productive persons, not just another burden on the state. I want, in the words of one serving life without the possibility of parole, I want to find out what adult responsibility is. I want a job. I want to pay rent. I want bills. I want a family and all the good times and the heartaches that come with it. Basically, I want a chance to show all of my detractors that I am not a disposable person. I do have worth and I can contribute to society. Sticking with many of my clients through adulthood, I also see the impact that their worst few seconds imaginable have had on the rest of their lives and their families. It shapes them. And in circumstances when they are released, in my experience, with some of those testifying before you today that you've had the opportunity to hear from, they get it, they change. But without the chance to be out of prison, to acknowledge their personal success in becoming a new person, they languish. This bill is not about having adequate counsel at all stages, trial, appeal, or post-conviction. Indeed, whether or not they had adequate counsel, a fair trial, or received all the due process rights is not an argument here and is not an issue. Instead, it is about recognizing that there is a need for change in the law that will align itself with scientific evidence, and to acknowledge this for those that have come before. I don't think it was ever intended to perpetually warehouse these children who have slipped from us at an early age and who have been fixed, so to speak, especially if science says we should. This legislation squarely fits a flaw in the system. I strongly urge you to support this legislation and give some of these kids the opportunity to now just go home. Thank you.
Thank you very much. Before we go to any further testimony, now, Speaker Hamburg, it's about 5 after 9. Your bill is also the next bill, though. With your permission, I can continue this hearing, and I will, on 276 at 10 o'clock, we're going to stop the hearing on that one also. Do you wish me to pursue this further, or do you want to go into the next bill? Very good. Well, I'll continue on to about 9:20, and then we'll have 40 minutes for the next bill. Will that be satisfactory to you? It will be. Thank you. You're welcome. Ms. Bisbee, would you like to go next?
Yes, thank you. I'm Connie Bisbee, Chairman of the Nevada Board of Parole Commissioners. I appreciate the Speaker's bill, and I understand the heart of it. I will make a suggestion, however, that when considering this bill, that maybe if you just narrow it down to Section 2 and pass the sentence of death or life imprisonment without the possibility parole can't be imposed on a perpetrator under the age of 18, and leave it at that. I will tell you that the brain science is well known by the parole board. I suspect it's also well known by our court systems. We consider everything about everything in any parole situation. I could understand based on that why you would want to not sentence a juvenile to life without or death, and could support that, but I think it could be simplified down to just approving Section 2 and not needing to go into the others. And for some very specific reasons, when you start talking about this 15-year period, and I realize that the gentleman that assisted with that doesn't currently live in the state of Nevada. In July of 2014, it became law that we have an aggregated sentence scheme in the state of Nevada. So what that means is if you have one of these young persons that commits a crime and they get consecutive sentences, and they don't have a high as minimum as 15. let's say the crime is such that there are 4 consecutive sentences and they're all 10 to life. Under mitigation, the way the court must sentence this in terms of what's going to appear on the judgment of conviction is that 4 cases, consecutive cases of 10 to life will turn into 1 sentence of 40 to life. So if you go into this minimum of, this maximum of 15 years before you consider this youthful offender for parole eligibility, I'm not quite sure how you would apply that to Nevada's aggregated sentences. We have a very good pardons board here. There are a lot of things that happen that if there are specific situations about a particular case that even with the example I gave you of 40 to life, that they have opportunity to have the pardons board look at that and reduce that minimum sentence. So I would really encourage you to just concentrate on that section 2, and that might be what you want to look at. I think that the authors of the bill did not necessarily think of all the particularities of the sentence structuring in the state of Nevada, so I would encourage that. And as I said, both the courts and the parole board are very aware of the youthful brain issues. One of the things that most of your youthful offenders that spoke here this morning said that's the really important part that you need to hear is that they got educations, they got job skills, they came out of prison with the ability to act as responsible tax-paying adults. If you take that same youthful offender and you put them out or require that they go out early, that they don't have those particular skills, you haven't done anything for them. And I think that your experts, Dr. Fine with the juvenile authorities in the state of Colorado has done a lot of lecturing on this, that if you don't meet those requirements while you have one of these young people in prison, you don't do them any good by putting them out. And you don't do public safety any good by putting them out. The examples you had this morning were young people that were in the right systems and got the right education, the right treatment. So, and I'll stop rambling on and just tell you that I will encourage you to look at this bill, but concentrate on Section 2. I think that if you just pass Section 2 as the change to the law, that you'll meet what is really the heart of the bill. Thank you.
Thank you very much, Mrs. Bisbee. I guess the record should reflect that she did sign in the neutral position on this, so.
Absolutely. I'm not here to crash it or to say yay, 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 but I think if you just look at Section 2 and consider making that the totality of the bill, that it meets all those needs.
Very good. Thank you very much. Ma'am, go ahead.
Hello, members of the Judiciary Committee. Thank you for letting me speak. My name is Rita Sloan. I am the coordinator for the Life, Peace, and Justice Commission of the Catholic Diocese, but I'm not here in that capacity today. I am also the coordinator for the Alternatives to Violence Project in Nevada, and this Alternatives to Violence Project, or AVP, conducts workshops in prisons. And they're intense workshops to help people, to help all of us consider the possibility of changing our ways. And we've been doing these workshops in this system for probably, I think it's around 13 years. I've been with the program for almost 12. I will never forget the first time I met a man who told me he had been in prison for 18 years, and he didn't realize he'd already told me his age at another time. He was 35, and I was shocked. I could not believe that someone that young was still in a prison and had gone to a men's prison. Well, sadly, since then, I've met many such people, and I am no longer shocked. But as a mother and as a grandmother, a mother of 5, grandmother of 10, it breaks my heart to think of putting children in prison, and to put a child in prison for the rest of his life makes no sense to me. So just a little bit further, I would like to say I know one of these 16 that has been talked about personally. He has been part of the AVP program as an inside facilitator for probably 5 or 6 years now. This man had already been on a path of positive change in his life when we met him and when he encountered AVP. But he credits AVP with furthering himself down that path of positive change. And he is an excellent facilitator. It's an all-volunteer program. He gets no benefits from the prison for being part of this program. And he does it because he helps other people, encourages other people to make these positive changes in their lives. And he continues to grow as a fine person himself. And so I strongly urge the passage of this bill and to retroactively.
Thank you very much, Mrs. Sloan. Before we go to the next folks up here, I'm going to go down south. Is that Father O'Callahan I see there? Or is it Brother O'Callahan?
It's Deacon O'Callahan.
Deacon, all right.
Mr.
I was
Chairman,
close.
committee members, thanks for the promotion. For the record, my name is Deacon Tim O'Callahan. Today I'm representing the Roman Catholic Diocese of Las Vegas, RAIN, the Religious Alliance in Nevada, and myself. Mr. Chairman, I am the youngest child of the former governor of Nevada, Michael Callahan. This will most likely be the only time I introduce myself as such, and for good reason. My father was not only the governor of this great state, he was a chief juvenile probation officer, a Clark County school teacher, a boxing coach, among other accomplishments. He was an undeniable champion for young people. He was a man who believed in accountability. As you may well know, he signed the death penalty into law in 1973. He was also a man who believed in redemption of human beings. Growing up in the governor's mansion, I witnessed his expansion of the work program for trustees. And on any given day, there were 4 inmates working in the mansion and on grounds, learning skills to help them stay out of prison when they were released. There's a long list of hardcore offenders who are allowed to redeem themselves and return to society, rehabilitated until their deaths. Mr. Chairman, redemption is possible. As a former newspaper publisher and columnist turned ordained Roman Catholic deacon and lobbyist, I can affirm redemption is possible, at least partly. I'm still working on the lobbyist thing. I prefer to be called the advocate for human dignity. However, that is a bill for another session. Today, I'm here to advocate on behalf of AB 267 that will eliminate the sentences for life without the possibility of parole for juvenile offenders. This bill should be called the Redemption of Human Dignity Act. How often in our youth did we do something that we were not proud of or just plain regretted? Heck, what about our adult lives and just this past year? My dad raised us with an iron fist, and he governed likewise. He was known in the hallways of the legislature as someone who was aggressive, demanding, a lion tamer with a whip. However, he also believed in compassion, forgiveness, and mercy, earning him the respect and friendship of both sides of the aisle. Under current law, juvenile offenders who commit violent crimes at an age where they lack the cerebral development of executive thinking are not afforded the opportunity to redeem themselves and return to be productive members of society. They are left hopelessly imprisoned until death or pardon. There is no human dignity in this. Just this past week, Pope Francis has called for an extraordinary holy year of mercy, a jubilee, a time for the entire church to spread the word of God's forgiveness and mercy, a practice dating back to the year 1300. While the church observes an ordinary holy year in the 25-year marks of each century as an equivalent to the ancient Jewish custom of Jubilee, a designated time for forgiveness, renewal, and celebration. In that same spirit of Pope Francis and the example of Michael Callahan, I encourage you to pass AB 267, bringing mercy, forgiveness, and full redemption to juvenile justice in this great state of Nevada. Mr. Chairman and committee members, thank you for your sacrifice and service to the people of Nevada. Thank you, Mr. Chairman.
Thank you, Deacon O'Callahan. Come an interesting historical point. My dad ran against his dad for governor in 1970. I didn't get to grow up in the governor's mansion. All right, with that, I'm going to have you three testify. That I'm going to have to shut down the hearing for the proponents. We've already had one person in neutral testify. There's nobody signed up in opposition. So we'll try to wind this thing up at 9:20 and then allow Speaker Hambrick to go with his next bill. Sir, go ahead and state your name for the record and proceed, please.
My name is Mike Dyer, and I am the director of the Nevada Catholic Conference, which is the vehicle through which the bishops in the state of Nevada, the Catholic bishops, speak on matters of statewide importance. And I'm simply here today to state for the record that the bishops and the Catholic Church in Nevada strongly support the passage of this bill as is.
Thank you, Mr. Dyer. Sir, go ahead and state your name for the record and go ahead.
Good morning, Chairman Hanson and fellow Judicial Committee members. My name is Marvin Neal. For most of my adult life, I have devoted myself to serving Nevada's at-risk youth. For the last 25 years, I volunteered at our local Juvenile Justice Center, now known as the Jan Evans Juvenile Justice Center. I do this because of the problems I had as a youth growing up in a dysfunctional family, a family where there was no father figure or role model to teach me what was right and how to do right. As a consequence of that experience, I spent I did time on a 6-to-life sentence in California, followed immediately by a 24-year sentence here in Nevada. However, while doing that time, I remember two men came into a dorm where I was doing time, and they said something that totally got my attention and has changed the course of my life. They said, "You know, men, it doesn't matter why you're here. God still loves you, and he cares about you. And if you let him, he can take this mess that you made of your life and make something good come out of it." That pierced my heart, and I wanted that. I didn't know if it was true, but I wanted that. I was looking at a 6-to-life in California, as I said. I was looking at up to 30 years here in Nevada. I only got 24. But I also was looking at an armed robbery charge in Wisconsin, where I came from. And so as I looked at all of that, my first thought was to commit suicide because I thought I had ruined my whole life. So my thought was to just end it now and get it over with. However, those words would not leave me. I'm going to fast forward to make this quick. Today, I am the chaplain at Jan Evans Juvenile Justice Center. And I think that all of you would agree, to go from being an ex-felon, serving time in a detention or correctional facility, to being appointed to a position of authority in one of these institutions, bespeaks not only rehabilitation, but a high level of trust as well. I'm here today in support of AB 267 because I was given another opportunity. And as chaplain at Jan Evans, where I've worked with young people for the last 25 years, I have seen a number of the young men that are in prison right now on murder without the possibility of parole. In fact, I am even mentoring one that I'm working with right now that is in the detention center. What I have learned from this experience is that these young people are no different from myself. Given the right opportunity, these young people can become highly productive citizens out here in our community again also. And I would encourage all of you to support this bill because we give them an opportunity to do something that can help them become productive in society, but more times than not, as we even heard from the other young men and young ladies that have already did time on murder beef, when they come back out, they really want to do something to help, not continue the destructive path that they were on. They got the right intervention, and I believe that if we give these young people that intervention and that help, we would find them out there doing similar works to what I'm doing, if not the same work, of helping others. And I can tell you, over my 25 years, I've ministered to and mentored and counseled thousands of young people. One of the reasons I was appointed as a chaplain was because the chief of juvenile justice it was then Wittenberg Hall, called me into his office, and he said, Marvin, we need to have a chaplain, someone that can mentor or counsel these young people when we can't let them out when there's a tragedy or something that has happened at home. And we would be remiss if we didn't offer you that opportunity first, because we see your ability to connect with these young people and to work with them in a way where they gravitate toward you. I believe the first time that I went into Jan Evans, I went in just to share my testimony of what God had done in my life. They had an invitation, an altar call, and over 90% of the kids that was there stood up and invited God into their life. I have continued to see that happen over the 25 years that I've been there. More importantly, the majority of the young people that go into that detention center, this is all voluntarily. They choose to come in because they are looking for help. They want help. And I'm asking you to give them that help, to give them a second opportunity. Thank you.
Chaplain Neal, thank you for what you've been doing. Very inspiring testimony after what you've come from. I appreciate that very much. Ms. Spinazzola, before you go, Mr. Jones, are you here to testify in favor of the bill? Okay, it's going to be a quick ditto then. You're going to be the final one, Ms. Spinazzola, and then we have to move on. I'm sorry.
With your permission, I'd rather defer to Megan Hoffman from the Federal Public Defender's Office for my testimony, if that's okay.
Megan? Okay, fine. We'll do that. It's got to be brief. We're already 5 minutes over the allotted time that I agreed to extend it, so that this will be the final. Tell you what, Megan, before we go to you, Mr. Jones, you just want to do a ditto or what?
Thank you, Chairman Hansen, members of the committee. My name is John Jones on behalf of the Nevada District Attorneys Association. I do want to say that we are in support of this bill. We do have some issues with the retroactivity portion. We are working out those differences with the Speaker Hambrick and James Dold, and hopefully by the time this bill comes up for work session, we'll have ironed out those differences.
Excellent. I understand Ms. Bisbee will probably also need to be in that. All right, let's go down south. This will be the final person to testify in favor of the bill at this time. Go ahead, ma'am.
Thank you very much for allowing me this few extra minutes. I won't take much of your time. My name is Megan Hoffman, and I'm appearing on my own behalf today, but I also am the chief of the non-capital habeas unit for the Office of the Federal Public Defender here in Nevada. And as a result of that representation, I have had the opportunity to represent several juveniles who have life without parole sentences in Nevada. I've been asked to speak today specifically on the development of the law here in Nevada on that issue. You've heard from countless examples today of juveniles in Nevada and across the country that have changed their lives once given a chance for release from prison. The juveniles from Nevada that you heard from today were fortunate enough to be given a chance for release. They, however, did not have life without parole sentences, and I want to be clear that what we are talking about today are the 16 inmates who cannot speak for themselves today because they remain incarcerated. In Nevada, their sentence is literally a death sentence. One of the committee members asked earlier, what is the age range that we are talking about here? And according to what we believe to be the list, there appear to be approximately 3 15-year-old juveniles. The rest are 16 and 17-year-old juveniles. And I would also like to note that we have attempted on many occasions through various different measures to obtain firm data from the Nevada Department of Corrections and have been unable to do so, as they apparently do not keep any sort of records on inmates that came into their prison as a juvenile. As you've heard today, the United States Supreme Court has recognized that if death is different, so are children. And while the court recognized that the cases before them were indeed vicious, and that is a quote from the United States Supreme Court, they also recognize that the Eighth Amendment to the United States Constitution prohibited sentencing children to a de facto death sentence. What the law basically holds is that the children must be provided a meaningful opportunity for release. That is all we are asking for in this bill, a meaningful opportunity for release. And earlier there was some testimony in opposition concerning the parole factors. And I'd like to make clear that what we are asking for here is a change. The juvenile life without parole defendants do not have an opportunity at this point in time to have their sentences aggregated. They do not have an opportunity for release. They do not have an opportunity for parole. And the majority of them do not have an opportunity for pardons. There is no opportunity but this bill. And so in terms of the aggregate sentencing that was mentioned before, what we are asking for here today and what we have agreed to with the DAs and part of our negotiations is to increase the bill to the 20 years rather than the 15. That would make these defendants who have served 20 years immediately eligible for parole. That is complying with the United States Supreme Court mandate that children be provided an individualized determination and opportunity for meaningful release. That does not mean that any of those men young men will be released, in fact. It is simply proviso. And so for those who have only a murder sentence, as we are writing this, they would immediately be eligible for parole. That has nothing to do with the aggregate sentencing. Further, in response to the testimony about the 20 years and possibly some sort of danger in releasing them before they've had an opportunity to program, I also believe that this bill covers those concerns. This bill releases no one or provides no one with opportunity for release until they have served a minimum of, currently the bill is 15, we're asking for 20. And all of the people that have spoken to you today have served 20 or somewhat less than that time, and we're able to complete the programs that made them such productive citizens upon their release. So I just want to talk very, very briefly about how this applies to Nevada.
Ms. Hoffman, I'm sorry. I'm going to have to.
Yes.
I'm going to have to shut it down at this point. But thank you very much for your testimony. You can submit that in writing, if you will, and we'll be happy to review it. I'm sorry to cut you off, but we're already almost a half hour over. So thank you. Is there anybody who'd like to testify in opposition to this bill? All right. We already had one in the neutral position. Anybody else in the neutral position at this time that needs to come forward? All right. We are going to shut down the hearing then on Assembly Bill 267 at this time. Thank you all very much for your testimony. And we're going to open. All right. Next up, Assembly Bill 267.
Thank you, Mr. Chair. Diane Thornton for the record. Assembly Bill 267 revises provisions concerning the sentencing and parole of persons convicted as an adult for a crime committed when the person was less than 18 years of age. It's sponsored by Assemblymember Hambrick, Hickey, Anderson, and Senators Hammond, Parks, and Ford, heard in committee on March 27th. The bill eliminates the imposition of a sentence of life without the possibility of parole upon a person convicted of certain crimes who was less than 18 years of age at the time the crime was committed, thereby making life imprisonment with the possibility of parole the maximum punishment. A court must consider certain mitigating factors in determining an appropriate sentence to be imposed upon a person who is convicted as an adult for an offense that was committed when he or she was less than 18 years of age. The bill provides that a prisoner who was sentenced as an adult for an offense that was committed when he or she was less than 18 years of age is eligible for parole after the prisoner has served 15 years of his or her sentence. The State Board of Parole Commissioners must consider certain mitigating factors when determining whether to grant parole to such a prisoner. Amendment is on the following pages. The amendment was proposed by Connie Bisbee, Parole Board, John Jones, Nevada DAs Association, James Dould, and Reagan Comis. It's there for your consideration, Mr. Chair. Thank you.
And I believe those were considered friendly amendments. All right, I'll entertain a motion on Assembly Bill 267 from Mr. Thompson with a second by Mr. Araujo. Is there any further discussion on this one? Mr. Thompson.
Thank you, Mr. Chair. And I believe I'm speaking for some of my colleagues. We'd like to know if we can be amended on to the bill. So Assemblyman Anderson, Assemblywoman Diaz, and Assemblyman Araujo.
Okay, how about Mr. Orenshall? Do you know? Can you speak for him? He's already on it? Okay. All right, very good. We'll make that notation. We'll get your names amended into the bill as co-sponsors. Floor statement. Let's see. Mr. Anderson, you're up next. Would you be willing to do that one? Oh, I haven't called the vote yet? Pardon me. We had the motion, right? Yeah, we're still in discussion. Any further discussion? All those in favor of Assembly Bill 267, say aye. Aye. No opposition? All right. Mr. Anderson, would you handle the floor statement on that?